New York Times Company versus Sullivan, 1964 case. All you need to know about Montgomery police, civil rights advertisements, and freedom of expression versus actual malice, which I will define later. Alright, so some facts about the case. Sullivan, the respondent, sued the New York Times Company, the defendant, for publishing an advertisement that made negative remarks not only about the Montgomery police force, but also specifically towards Sullivan. I say specifically because he was the police commissioner at the time. Now, this advertisement claimed that the police were targeting Martin Luther King's efforts to integrate public facilities and to encourage voting among African Americans. Basically, that means that the police were trying to stop any civil rights movements going on in the area, potentially by using police brutality. So, New York Times is very critical of this. Interestingly enough, though, under Alabama law, Sullivan did not have to prove actual malice to win the case. So this meant that he didn't have to prove whether or not the statements made by the New York Times were false or whether they were true. So, because of that, he ended up winning a $500,000 judgment in Alabama state court. This is the equivalent of compensation or punitive damages that he received for having to go through this trial and for winning. The case, however, was then appealed, and it ultimately was overturned by the Supreme Court with a unanimous vote in favor of the New York Times. So drastic turnaround there, and this is largely due to what happened where the judge did not have to prove actual malice, and I will come back to that later. So right here is the New York Times advertisement. It was called Heed Their Rising Voices. I will post a link to some sort of format of this article in the About section of this video, so anyone who's interested in reading it can go ahead and do so. So this is the Supreme Court decision, and the Supreme Court voted unanimously in favor of the New York Times. The Supreme Court Chief Justice at the time was Earl Warren, who could either write the majority opinion himself or could assign it to someone else. In this case, he signed it to William J. Brennan. Now, the majority opinion is basically a really long statement saying, this is why we voted this way, and just fully explicating it, etc., etc. Concurring opinions were then written by Hugo Black and Arthur J. Goldberg, and to these two, William Douglas ended up concurring with them, saying, yes, I agree with points in both. Concurring opinions are different from majority opinions in that even though these guys voted the same way, they voted that way for different reasons, and they write these opinions to explain what caused them to vote the way that they did. So here's the Supreme Court's decision, and these are some specifics about that. So the Supreme Court upheld that unless actual malice can be proven, the First Amendment ends up protecting the New York Times, because the New York Times, under the First Amendment, has the freedom of expression and the freedom of the press. So this is really interesting because, as I stated earlier, actual malice did not need to be proved in Alabama state court. But then look here at the 14th Amendment, where the Supreme Court upholds that a state cannot award damages in a libel action case without proof of actual malice. So when Sullivan won the case in Alabama, that actually wasn't appropriate because the judge refused to mention that actual malice had to be proved before Sullivan could win this case. So when he received that $500,000 from winning the case, he ended up never actually getting that money because when the Supreme Court received the case, they overturned the verdict in favor of the New York Times. So Sullivan was never paid, and actual malice did need to be proved in this case with the Supreme Court. So I've been talking about actual malice a lot, and I'm just going to go ahead and clear up again by redefining it. It is knowingly false, published information intended to hurt its targeted individual. It can also be recklessly published without really checking whether or not these facts are true or whether they are false. So the reason that the New York Times did not do anything that proved actual malice was because they were not trying to target Sullivan. They were just expressing their opinion on what was going on in the civil rights movement. And in a democracy, it kind of makes sense that not everything you say is going to be agreed with by everyone else, but that doesn't necessarily mean that you're purposely trying to hurt any specific individual or corporation. So that's why for the New York Times, they were able to win this case, because they were simply exercising freedom of expression and of the press and were not in any way trying to harm anyone. So why exactly did the Supreme Court take this case? Well, in 1964, another really important piece of legislation was going to be passed, the Civil Rights Act. The Civil Rights Act was passed a little bit after the verdict of this case was made, but the ideas within the Civil Rights Act and what happened here still kind of apply to one another. So, the Civil Rights Act is a legislative outlaw of discrimination based on color, race, religion, sex, or national origin. Notice that it says color or race. the Civil Rights Act was not very popular, but it was strictly upheld. So take somewhere really southern like Montgomery, Alabama, where this was definitely not very much advocated for, but then also take the fact that under the law, discrimination was now no longer acceptable. So when you see the Supreme Court rule in favor of the New York Times in publishing this advertisement, you see that they are saying, hey, we agree that the civil rights movement is fine. It's okay if you want to publish this advertisement, even if it's critical, because we don't want discrimination anymore. We want integration. So we have no problem with the New York Times expressing its opinion, especially because it's in favor of this legislation that we're eventually going to pass, because both concern civil rights movements and the idea that discrimination is no longer acceptable, and we are going to be pro-integration. It could also be possible, aside from that the New York Times is very popular. It has a lot of influence. So the fact that it is very widely known could have also impacted the fact that the Supreme Court decided to hear this case. Why was the decision unanimous? Well, as I stated before, the Civil Rights Act of 1964 was also passed around this time. Voting in favor of the New York Times Company showed that the Supreme Court took the Civil Rights Act seriously, and also that they were going to definitely stand publicly in favor of anyone who also is accepting of the civil rights movement and criticizes discrimination. So by the Supreme Court acting together as one mind, they're saying, hey, we're ultimately going to pass this legislation, and anyone who's in favor of that is fine with us, and furthermore, that we are going to stand together as one body. So everyone on the Supreme Court was saying legally discrimination is wrong, and we have no problems with anyone who wants to freely express their opinion on the matter, because it also positively reflects our own. Alright, so here is a very brief summary in comic form. If there's anything that you didn't quite understand in the video, this is a really simple way to figure out what was going on in this case. In the first box, you have Sullivan saying to the New York Times, you published this ad lying about me in the newspaper. I don't like that. I'm suing you. Then you've got the New York Times countering saying, well, wait, under the First Amendment, we have freedom of speech, expression, and press, all of that together. So the New York Times is saying, why are you suing us? We can easily do this, and it's not a problem. It's constitutionally protected. Then you've got in this third slide here, the Supreme Court saying, we've decided to go with what the New York Times is saying. We agree. It is a constitutional right, so we're going to unanimously vote in the New York Times' favor. Sorry, Sullivan, but you don't get your $500,000. So if you didn't understand it, that's a really easy way to look at it. Here's my works cited in case any of you guys want to look up this information. I'm going to go ahead and post a couple links in the About section of this video for anyone who wants to read up on it. And I just want to say thank you for watching. I hope you enjoyed this video.